Hi, good morning, everyone. Welcome to Dr. K.K. Agarwal's Heartcare Foundation. Good morning, everyone. Welcome to Dr. K.K.'s Heartcare Foundation of India. And we are live on 69th session of DMA NDB Doctors Meet. This happens every Sunday at 9:30 a.m. We always have this topic which started by Dr. K.K. Agarwal, and Dr. Nidhi and Dr. Meenakshi, Dr. Preeti, they all take care of this session post that. Today, we have bring two experts on this topic of medical negligence. This is one of the very, very important aspects which not only is important to a doctor, a regular patient, but it is also very important for a relationship between a patient and a doctor. So to talk about these topics, I would like to introduce two speakers. We have Dr. Pankaj Vats. He's an MD Forensic Medicine, AIMS Delhi. He's a medical legal consultant, toxicologist, forensic expert. He's a senior consultant, PNDT, MTP, CEA, Consumer Protection Act of all medical laws. He's a former district appropriate authority cum civil surgeon. He has formerly also worked as a director of health services, family welfare, cum member, state supervisor board. He is a national president for Ayushman Bharat Swasthya Parishad. He is also the chairman cum executive director of 5i Medico Legal Consultancy Services. Our second speaker on board is Advocate Ira Gupta. She has with over 12 years of experience in handling all the variety of matters in diversified field. She is present, appears in most of the courts in Delhi, including Supreme Court, High Court, District Court, and all the forums. She's a partner with Privy Law Firm. She has filed many PILs before Supreme Court and High Court on various public health issues. She's also the legal advisor for Heartcare Foundation of India. She has been working with Dr. KK for a while, and a lot of PILs which have been filed are filed jointly. We are live on Facebook and YouTube, and now I would like to invite Ira for presenting the slides and Dr. Vats later on to talk on this topic. So we have a medical aspect and we have a legal aspect. Over to you, Ira.
Thank you so much, Saurabh. Good morning to everybody. Yeah, is my screen visible to everybody?
Absolutely, you can start the presentation. Thank you.
Okay. So good morning, everybody. Today we are talking over here about medical negligence. So first important thing to know is why is it important for the doctors to know about the medical negligence or medical legal aspects? See, one of the most important reason why we are talking about this topic today is there is a spurt in number of complaints and cases of medical negligence being filed against doctors, and not just doctors, it is being filed against hospitals also, healthcare professionals in general. Then doctors are mostly ignorant of the legal aspects of the practice. Doctors are mostly ignorant of the legal aspect of practice of medicine corresponding increase in the compensation awarded in medical negligence cases. So in 2012, in the Honorable Supreme Court of India, in the Dr. Balram Prasad versus Dr. Kunal Saha case, had come out with the compensation formula. Now, because of that formula, the courts, Supreme Court, even the Honorable National Consumer Commission have awarded a compensation which are running into crores of money. So these are the four major cases in which the compensation have been awarded to the patients, and this compensation had to be paid by the doctors, which were more than 1 crore. is our Nizam's Institute of Medical Sciences versus Prasad S. Dhankana, Dr. Indu Sharma versus Indraprasth Apollo Hospital, V. Krishna Kumar versus State of Tamil Nadu, and Dr. Balram Prasad versus Dr. Kunal Shah. So because the compensation amount are running into crores of money, it is important that all the doctors should know what is the medical legal thing, what are the medical negligence, what are the defenses they should take, and what are the responsibilities of the doctors are, and what are the precautions the doctor has to ensure while treating the patient. So let us first understand the term negligence. Negligence is the breach of a duty exercised by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. So the definition of negligence contains following constituents. One is legal duty to exercise due care, breach of duty, and consequential damage. So negligence means if a doctor is supposed to do one particular thing and he's not doing that particular thing, then there is, and because of his not doing, there is some damage or injury caused to the patient, then that amounts to negligence. This is general definition of negligence. Medical negligence comprises of the following constituents. So for contributing any doctor and saying that the doctor has committed any kind of medical negligence, then these 5 major points are important to be disclosed. And they should be a legal duty to exercise due care on the part of the medical professional, a failure to inform the patient of the risk involved, patient suffers damage as a consequence of the undisclosed risk by the medical professional. If the risk had been disclosed, the patient would have avoided the injury. Breach of the said duty would give rise to actionable claim of negligence. So if there is a particular, the legal duty of the patient doctor is to ensure that the treatment is done properly. If there is and if there are some risk involved, the doctor is supposed to inform the patient and his relatives about all the risk involved and should try to avoid all those undisclosed risk which may be there. If the doctor has not disclosed about all those risks and the patient has suffered some damage, then yes, there is a medical negligence on the part of the doctor. Actionable medical negligence. See, not all kind of medical negligence or medical errors are actionable. The actionable medical negligence is the neglect in exercising a reasonable degree of skill and knowledge to the patient to whom he owes a duty of care, which has resulted in injury to such person. The standard to be applied for adjudicating whether the medical professional charged has been negligent or not in the performance of his duty would be that of an ordinary competent person exercising ordinary skill in the profession. The law requires neither the very highest nor a very low degree of care and competence to adjudge whether the medical professional has been negligent in the treatment of the patient. A medical practitioner would be liable only where his conduct fell below that of the standards of reasonably competent practitioner in his field. Responsibilities of the doctors. To continue to treat except under certain circumstances when doctor can abandon his patient, to take reasonable care of his patient, to exhibit reasonable skill. The degree of skill the doctor undertakes is the average degree of skill possessed by his professional brethren of the same standing as himself. The best form of treatment may differ when different choices are available. There is an implied contract between the doctor and patient, where the patient is told, in effect, medicine is not an exact science. I shall use my experience and best judgment, and you take the risk that I may be wrong. I guarantee nothing. Not to undertake any procedure beyond his control. This depends on his qualifications, special training, and experience. The doctor must always ensure that he is reasonably skilled before undertaking any special procedure or treating a complicated case. See, in any kind of medical treatment, no 100% guarantee can be given by the doctor to the patient. So no doctor can give 100% guarantee that the treatment or surgery will be successful. The only assurance which a doctor can give or can be understood to have given by implication is that he is possessed of requisite skill in that branch of profession which he is practicing, and while undertaking the performance of the task entrusted to him, he would be exercising his skill with reasonable competence. Simply because a patient has not favorably responded to a treatment given by a doctor or a surgery has failed, the doctor cannot be held straightaway liable for medical negligence by applying the doctrine of res ipsa loquitur. Different diagnosis or treatment. So there are different diagnosis and treatment line of treatment for a particular problem. So in the realm of diagnosis and treatment, there is scope of genuine difference of opinion, and one professional doctor is clearly not negligible mainly because his conclusion differs from that of other professional doctor. Mainly because the doctor chooses one course of action in preference to the other one available, he would not be liable if the course of action chosen by him was acceptable to the medical profession. The medical profession is often called upon to adopt a procedure which involves higher element of risk, but which he honestly believes as providing greater chances of success for the patient rather than a procedure involving lesser risk but higher chances of failure. Just because a professional looking to the gravity of illness has taken higher element of risk to redeem the patient out of his or her suffering, which did not yield the desired result, may not amount to negligence. So 5 days back, there is a recent judgment passed by the Honorable Supreme Court of India, by, titled as Dr. Harish Kumar Kurana versus Joginder Singh and others. In this judgment, the Honorable Supreme Court has specifically said, in every case where the treatment is not successful or the patient dies during surgery, it cannot be automatically assumed that the medical professional was negligent. In this case, this Honorable Supreme Court has overturned and set aside the order of the National Consumer Dispute Redressal Commission, primarily finding that a case of medical negligence had not been established against the appellant, that is the doctors, through medical evidence, but rather by applying mere legal principles to technical medical issues. So we will discuss a little bit about this judgment because it has come out to say that medical evidence is important in attributing any kind of medical negligence to the doctors. So the brief facts of the case are, in this case, the patient's claimant's wife was admitted in the hospital after diagnosed with kidney stone, died after a surgery performed on her. Alleging medical negligence, the claimant approached the National Consumer Dispute Redressal Commission. The National Consumer Dispute Redressal Commission held the doctor and hospital guilty of medical negligence and had directed to payment of rupees 17 lakhs only with the interest as compensation. In the appeal, the bench noted, the Honorable Supreme Court noted, apart from the allegations made by the claimants before NCDRC, there is no other medical evidence tendered by the complainant to indicate negligence on the part of the doctor. So in this case, what happened was the claimants were only alleging that there is some medical negligence, but they were not able to come out with any medical evidence to prove that negligence has been committed by the doctors. So the Honorable Supreme Court has passed the following judgment, has said, in every case where the treatment is not successful, the patient dies during the surgery, it cannot be automatically assumed that the medical professional was negligent. To indicate negligence, there should be material available on record, or else appropriate medical evidence should be tendered. The negligence alleged should be so glaring, in which event the principle of res ipsa loquitur could be made applicable and not based on perception. In the instance case, apart from the allegations made by claimants before NCDRC, both in the complaint and in the affidavit filed in the proceeding, there is no other medical evidence tendered by the complainant to indicate negligence on the part of the doctors who, on their own behalf, had explained their position relating to the medical process in their affidavit to explain there was no negligence. So this was about mere reliance placed on the magisterial inquiry would not be sufficient. Though the opinion of the civil surgeon who was a member of the committee is contained in the report, the same cannot be taken as conclusive since such report does not have statutory flavor, nor was the civil surgeon who had tendered his opinion available for cross-examination or seeking answers by way of interrogatories on the medical aspect. Mere legal principles and general standard of assessment was not sufficient in a matter of the present nature when this very same patient in the same setup had undergone a successful operation conducted by the same team of doctors. So the conclusion as reached by NCDRC is not sustainable. This was a very brief about the medical negligence, though this subject is a very wide subject. And I hope now I transfer the mic to Dr. Pankaj Vats. Thank you so much.
So thank you, Ira, for giving the legal side of it. I would like to invite Dr. Pankaj Vats to introduce the topic and to keep his point of view on the medical aspects of medical negligence. Dr. Pankaj Vats is a medico legal consultant. Dr. Vats, can you please unmute yourself?
Hello.
Yes.
I'm audible now?
Yes.
Okay. Thank you, Ira. You have nicely presented what negligence is and what other factors are. And latest eye-opening judgment of the Supreme Court. It came only very recently. But I'll add in certain things about it, that what is the negligence? As far as Consumer Protection Act is concerned, medical negligence has two parts. One is that it is on the part of the treating doctor, and another is in providing the services. So when you provide the services, deficiency of services also come in negligence, and that again is attributed to the medical negligence. For example, if it is a nursing home or it is a big corporate hospital, so it is expected that doctors registered under Indian Medical Association Act will only be giving services there. It is presumed. But if there are the non-medical doctors, IMA doctors or Ayush doctors or others are say appointed in the hospital and they are giving services, so this will be amounting as deficiency of the services. It is understood that whatever the doctor will give the treatment or prescribe the treatment, that will be he will be prescribing, and that will be given by the trained staff nurses. If staff nurses are not trained, if paramedical staff is not properly trained, that in that particular case also this will be amounting as deficiency of services, and again it will contribute to the medical negligence of the doctor as well as of the corporate hospital. So we have to understand that there are two parts for medical negligence. It is non-medical reasons and medical reasons. And what exactly is happening, that most of these medical negligence cases are coming because they are very heavy bills, and when they lose their patient, their loving being in unexpected circumstances, then this also contribute that they go for medical negligence cases. So that is also very important part which we should understand, that all the doctors should ensure that either in their own clinical establishment or where they are working in these clinical establishment, the staff, trained staff and recognized staff is only recruited. Otherwise, negligence there cause there will harm their repute also, and they will face criminal as well as medical negligence cases. See, negligence, the second important part is about the negligence, that it can be of civil nature or it can be of medical negligence, criminal negligence part also. So we have to segregate these two also. You are liable for
Dr. Vats, you're not audible. Your connection is.
Hello.
Yeah, your connection is a little poor. I think we are not able to hear you out. Yes, now we can.
Now you are able to listen?
Yeah.
Okay. So we have to differentiate between criminal negligence and medical negligence. And what exactly happens, suppose if some death happens on, say, in the operation theater or post-operative period or subsequently, we immediately fall prey to the psyche that always the criminal action will be taken against us. And at that particular time, in anxiety or in hurry, rather than finding the cause of death, whether it was accidental, it was reason because of the beyond control of the doctors, or it was because of the negligence, or because of some shortcoming, is not evaluated. So that's why in hurry, we try to find out a solution, and then sometimes we try to manipulate the records also. And later on, when it is scrutinized by the law enforcing agency, then in spite of the fact that there was no negligence, we fall prey to that. So we have to differentiate our civil and medical. For that, how to safeguard yourself from the cases of the medical negligence, civil as well as criminal. The best thing is that every hospital, clinical establishment should have a review committee. Review committee for in routine also, so that not only on these cases where cases of the medical negligence has been labeled against us, rather each and every case of death must be reviewed, feeling that it may be a case of negligence. So while you are reviewing all those cases and in routine also, then you will come to know that what has to be done, what other safeguard has to be taken by you, what are the lacunas which can come as a problem for future. So there must be a review committee. That review committee should not be only the expert or officials of the concerned hospital or clinical establishment. There must be independent members on this review committee, or say review committee or review board. In that, they must keep 2 persons at least, it must be there. A medical legal expert with genuine experience and expertise, and second, they should have a legal person in that, so that what exactly happens when crisis comes, we only see it with one angle, only with the medical angle, and the medical board people try to review the particular situation and try to find out the reasons for it. Those independent members will be able to see that issues on behalf of the patient also, and they can also see how that can be reviewed by the legal framework in future in the court and the investigating agency. So it is better to have these particular review committees also. But we should not immediately feel that each and every case is negligence which you are facing. Moreover, these judgments, see what is law on medical negligence. There are certain acts which are applicable on doctors and nursing homes and clinical establishments. Then there are certain rules and regulations framed under the act. And there are a lot of judgments by consumer firms and courts, Supreme Courts, High Courts and all that. And all other instructions also. This all gets combined and then it is called as law. So therefore, we have also to see that all the medical laws, they are properly implemented our clinical establishments, and whatever our medical associations have cited, those must also be followed. Then second thing is that we should also be aware about the latest and previous important judgments also, because when judiciary review the cases, so they draw inspiration and guidance from the laws, the judgments passed by the higher authorities or higher courts. As far as actionable medical negligence is, this is true. Advocate ma'am said it rightly, that gross negligence has to be there. Gross negligence has to be there. It is very important. And for that, courts also apply the principle of res ipsa liquiter, meaning thereby that whatever is very evident, they speak of themselves. वो खुद चीजें बोलती हैं, ऐसी चीजें जब सामने हो तभी वो मेडिकल नेग्लिजेंस की कैटेगरी में आती हैं, ग्रॉस नेग्लिजेंस में. Suppose a surgery is conducted or assisted by a Ayush doctor. So it apparently seems, you write in a hospital trauma center, services all the 24 hours. But when we go inside, then we see that it is only run by a single doctor. So in that particular case, it's a res ipsa liquiter. He cannot run a 24 hours emergency services one, and it cannot be a trauma center which can tackle the cases of head injuries also and other injuries also. So false claims like doctors, physicians having MD degree in physician, having experience of cardiology or neurology or diabetology, so they sometimes on their card they write it. There is a physician, cardiologist, or diabetologist, and other things. It also, so the patient goes with the belief that he's a cardiologist, and if he has some complications and all that, then it becomes his right, or court also can review in this way that it was a misrepresentation, and they can face the law. So responsibility of the doctors, I think, is that he has to take reasonable care. Every time a doctor has to keep two things in mind. One thing is that omission and commission. He should not omit a thing which it is expected from him as per his expertise. Commission means he should not commit a thing which is not expected from him. So omission and commission. Reasonable care of dignity, due diligence. These are the few factors which you keep, then you will not be facing all these questions like this. She is right, 100% guarantee cannot be given. Agreed. Judgments, with judgments come, there is a operative part or there is a descriptive part. So sometimes what we see is we go through the descriptive part and we feel that these are the observations or decision of the court. No, decision of the court, to arrive to the decision of the court has taken clues from those decisions and those descriptions. Like in this important case which Supreme Court has given recently, the best thing which the court has relied was that mere legal principles and general standards of assessment was not sufficient in a matter of the present nature. When the very same patient in the same setup had undergone a successful operation conducted by the same team of doctors. Hence, the confusion as reached by the NCR is not sustainable, because the court has relied on this particular statement. So, similarly, second thing is that doctors are very poor in documenting the things. Doctors are very poor to in documentation of the things. So this is very, very important that you must document whatever you observe, and that helps you a lot in coming to the conclusion and getting safeguards in there. About the consent also, every doctor knows that informed consent is required. But what is their concept? Recently, I had been in the KK Agrawal's program in 4th or 5th September, where a panelist and very senior doctor asked me, Doctor, please draw a exclusive consent so that I don't land in trouble and I get it signed from each and every patient. See, this we are feeling. So informed consent is not once which we in the initial stages in the hospital we come and we take. So informed consent has to be taken at several times, at several points, and several points. For each and every event, you require it. Moreover, the informed consent has to be taken by the operating surgeon at least, or the team member. It should not be left on the paramedical staff. So if the consent is taken, it has to be taken by one of the member of the treating team. Second thing is, about the informed consent is that it should be in the language of the patient, and language means in the language he understands. A layman, he may understand if you speak to him in Hindi or in his mother tongue or language, he will be able to understand or make him understand the language which understand. This is or should I continue?
Thank you, Dr. Vats, for giving the insight of the the medical negligence. We have some questions coming up from the audience, and we also have some questions on the Facebook and YouTube. Rightly said, communication is very important for any relationship, whether it is doctor or a patient relationship or anything else. So anybody on the floor would like to ask a question before we can take it forward? I see some questions on the chat box as well. So let me ask them. Dr. Sanjeev Agarwal is asking, there is no uniformity in the medicine. So how can a person perceive and decide? So the chance of error is always there.
See, it is very important that line of action or line of treatment can vary. But for that, see, we should be supported by the instructions or by the protocol given by our own associations. The association of surgeons is there, physicians are there, expertise are there, anesthetists also. So they have their own protocols. So we should review all these protocols in our meetings of our associations also, and it should be documented. It should be documented. We are very much recently in corona cases also, so many instructions got from the government of India or from WHO or something and all that. So it was also a very problem for the doctors at particular time also, which injection is to be given, which injection is not to be given, steroids are to be given or not to be given, when to be given, when not to be given. So that's why all these things, a doctor has to update himself with the latest version. He has to, that's why even our associations have told that doctors should get some grades or some points also for these reviews and all that. So we can have difference of opinion, even if we have even have a difference of opinion, and still we want to continue or not to continue with a particular treatment. it is better to write that particular and document it. For example, I am telling of my case in All India Medical Institute. There was some problem and all that. So one of the professor wrote that injection such and such to be given. It was a very costly injection. At that time, it was 1.5 lakh. It has to be given weekly, and number of injections, they don't know how many injections are to be given. So he advised on the file, and later on he wrote it. I still want to hold it, and that those injections were never given. When I tried to persuade him that I have got enough, by God's grace, I have got enough resources. You don't worry about the money and all that. Please give it because I'm in very grave problem. Then he personally explained that why, see, line of treatment is this abroad, but in your case or Indian circumstances, I don't want to give these injections till there is a life-threatening situation comes. So I was also satisfied, and if something would have been happened like this. So there can be difference of line of treatment, but it should be reasonable.
Okay. So I'll come back to you on this. But meanwhile, there is a question. Is there a standard of care? Is there any legal definition? Can I ask Ira for this answer? Is there any legal definition of a standard of care which is available in the medical negligence or a legal side of it?
Saurabh, standard of care has been defined by Honorable Supreme Court in various matters, and the standard of care, according to them, is the reasonable standard of care which any other doctor will be taking care while treating that patient. So if for example, let's nowadays the COVID is there, so there is a line of treatment of treating a COVID patient. If a doctor is following that line of treatment, and somehow even after following that line of treatment, the patient does not survive or patient suffers from any injury, then it will be said that the doctor has performed standard of care, the standard of care which was to be taken. But if suppose the doctor does not take care, does not follow the same protocol, does not follow the same line of treatment as he was supposed to follow, or he has been doing it with other patients, or the other doctors are treating the other COVID patients, then yes, he has fallen below his standard of care, what he was supposed to do it. So that is the legal definition of standard of care.
Okay, but my question to you both again is that, one, there is a protocol which has been defined like a standard of care. There are protocols which have been followed, but a lot of doctors which we have seen do want to take, because, a lot of problems which comes in the patient are also because of the experience they have over a period of time. And a lot of times they have to go as a deviation, which can actually result in a betterment for a patient. In us, like, we need to understand this is a profession of a trust, and patients do have an option to take a second advice as well. So when you go and approach to a doctor, he has some kind of a trust to go with that patient. And a lot of times that protocol is followed, but generally there is some kind of a deviation. Okay, you can take this permutation combination. In that, chances of an error, is that still a medical negligence? And if the doctor has a very good track record and he's a qualified medical practitioner which has a lot of things, even in that scenario, will that be a medical negligence?
Sort of that can see, when we talk about standard of care, we are not only talking about the medical protocol or standard procedure SOPs. We are also taking into consideration the qualification of the doctor, the experience he has in treating so many other patients, and what are the protocol. Then there are a lot of medical literatures available. So everything is to be taken and seen in every particular case, and then only the doctor and the patient and the courts can say what is the standard of care.
See,
Saurabh, I wanted to come in.
Yes, Doctor. Yes, Professor Bijon.
Yeah, firstly, let me congratulate.
Dr. Bijon, Dr. Vats was trying to speak something on the same topic. Can I just take you after that?
Yeah, please go ahead.
Yeah, Dr. Vats, you were trying to say something on that.
Yes, yes. Sort of what I want to say it. See, medical knowledge go on changing. Corona has taught not only doctors, they have taught the society also, and the legal framework also, that how the things go on changing. The treatment which the situation which we faced in the second wave were not in the first wave. The treatment which were supposed to give in the first wave, we didn't give the treatment, and there were new treatments for that.
Absolutely.
So that's why the one safeguard is that whenever these cases go to the medical form, or even they go to the criminal cases like and all that, then Supreme Court has very categorically stated that there has to be some medical evidence. So medical board's report or some evidence has to be of a person equally placed in the of that particular doctor which he has given. Because entirely a person who's sitting, a doctor who's sitting in the village or rural area cannot give the particular care and treatment which is supposed to be in a district hospital and which in a corporate hospital which has much advanced services. So that's why the Supreme Court has given categorically stated and again confirmed in several of the statements that it requires a report of a board whether doctors have given that particular treatment or particular line of action which have taken was proper or not.
So you mean to say the definition of the standard of care is different from a different environment? Okay.
Yes, yes, certainly. Different environment also. In medical field, 2 + 2 is not 4.
Okay.
Because suppose you are a patient, you went to a doctor with complaint of fever for 2 days, and you are not a very intelligent patient, and doctors try to ask you certain things. You only give importance to fever because your immediate suffering is from the fever, but you have not delivered all other signs and symptoms which you are facing, like burning of micturition or like other things and all that. So if only you give the history of fever to the patient, then doctor has to treat you and get you investigated the way he thinks. And
Okay.
suppose if I am sitting in I am sitting at a district hospital and I know patient has come all the way from 40 kilometers and he will not come again, then I will try to prescribe the medicines for a longer time. But if I know that this person has come from a nearby place or from the same place, so what I will do is I will not prescribe, may or may not prescribe the medicine on that particular day. I ask him to come next day with investigations done. So it is no perfect guidelines can be issued.
Okay, perfect. Professor Mishra, would you like to take the question?
Yeah, no, I would like to firstly give my perspective on behalf of the patients. You see, so the most important issue is very good presentation made by Ira and Dr. Vats. Ira should add one slide which should talk about why does a dispute arise?
Yes.
And analyze that, which is very important. That slide is missing, which is very important, that why does a dispute arise? That is number one. Number two, all of you are recommended to look at a code of conduct which was developed by IMA way back in 2004, 2005, which talked about the roles and responsibilities of a medical practitioner and a patient. So that code is acknowledged as one of the best publications ever done by WHO. So it could be seen and understood in terms of why these medical negligence cases are increasing in our country and why is it happening. So the very first thing is that there is a standard treatment guideline which needs to be adhered to. So there is a guideline already existing in terms of standard treatment, number one. Number two, we have got an agency called National Accreditation Board for Hospitals and Service Providers, which again sets standards for hospitals and also nursing homes and others, which gets NABH accredited or certified, depending on entry level or full accreditation. Now, the most important issue is, and which the Supreme Court has again reiterated in that order of 7th September, that every hospital must have a neutral body, which you can call ombudsman, review committee, whatever name you want to give it, you give it. But every patient has the right to approach such a body which is neutral, which is not biased, which will be of members or individual also, who is a reputed medical practitioner or a person of repute who understands medical sciences, so that based on certain evidences, he will give his verdict or his opinion. And that opinion will be binding on the hospital as well as the patient. That is a voluntary initiative which we have been trying to promote in India for many years now. At least I have been trying to do this for the last 20 years. But somehow the hospitals are very shy to invite such competent people in their locality to appoint them as ombudsmen or appoint them as experts attached in terms of any kind of a complaint which emerges against the hospital or the medical practitioner or the treatment provided to the patient. So till we don't have such kind of a mechanism in place, the cases will keep increasing in the various district commissions, state commissions, national commission, and even will go up to the Supreme Court, which will be utter waste of money, resource, and distrust in the system. So what we all need to understand is a patient profession is not to file a case. The patient has a trust, and because they have a trust, they approach a particular medical practitioner or a particular hospital because they trust that hospital. Now, if in many of the cases where we have studied, many cases are filed because they are motivated or they are being done with certain vested interest. That should be nipped at the bud itself. You know, in order to do that, these kind of mechanisms of science-based evidences being created right at the grassroots level, right at the root cause, is very important, and people must accept these kind of mechanisms to be introduced in a country like India, where we have a lot of illiterate people, we have a lot of people who are ignorant about law, but get motivated due to certain rivalry or professional rivalry or maybe many such matters, which actually tantamounts to filing of vested interested cases, which take away the precious time of the district commission and state commission. So my short point is that all the cases which has been settled, whether it's Kunal Shah or any kind of a case which has been settled, one point which has come into evidence is that if there is sufficient evidence which is science-based and which deems to give compensation to the consumer, should be given right away, right at the stage, early stage, rather than making that patient go to the court of law to seek compensation. I mean, my contention is the compensation amount increased in Kunal Shah's case because it went up to the Supreme Court. That's why the amount increased. If it could have been settled right at the beginning, then I don't think Dr. Shah would have taken all that trouble to go up to the Supreme Court. The issue is that if you have committed a mistake, and error is human, you should be courageous enough to say that I have committed a mistake and I'm ready to rectify it. I assure that it will not happen again. And whatever damage has been caused, we will pay to the patient without asking any questions. So based on science and evidence and based on experts' advice, which is attached to that hospital. So this is my only point which I wanted to share with the listeners and share with the experts in this group today. So I really congratulate you, Saurabh, and all your team members for having this conversation today, which is very important for us.
Thank you. So we do have questions coming up, and again, this was a patient.
Saurabh, one thing about Professor Misra made a very important point, that we should try to settle the issue at the beginning, because when the cases, I am handling the cases of medical negligence from both the sides, from the doctors to save them and for the patients for if they have really suffered. So what I do is I take an undertaking from the patient before I take him on my list, that if I don't find any medical negligence, then he's to drop the proceedings. And I literally speaking, I'm so happy, at least 25 patients were those who were able to understand that there was no negligence, and they dropped their cases even at the level of National Commission. And similarly, several doctors, which my own discussions and other things, and they came to know, yes, negligence happened. They became brave enough and they settled the issue. They called the patient, they called me also, and they said it, we realized that something has happened. And even those patients have shown the gross and they settled the issue. So that mechanism must be in each, say, big clinical hospitals at least.
Okay. So my next, yeah.
Just answer to Dr. Bijon's query. Why these medical negligence always come up? What is the reason behind it? So there are many reasons behind it. If we see why the patient, because one major reason which we normally face and we have seen in majorly cases is the patient is not being communicated about the treatment beforehand. So there has to be informed communication. We talk about informed consent, we talk about consent form, we take signatures on the consent form, we take signatures on the risk factors, but the communication part is not there as much as it should be. The relatives and the patients are not very well known about what is the line of treatment, what are the risks involved, what are the other options they have.
Ira, I would only recommend to you, that's why I suggested one slide should be made. We will talk offline on this. You should add one slide and highlight some of the issues which actually create these kind of communication breakdowns, which leads to dispute and goes into litigation. So we will talk on this offline, and I will suggest you how to make that last slide.
Also, I want to ask one more question over here. Since the country in India, and these questions I am asking because there are a lot of questions coming up, and I've combined one question for that. Communication is very important between a doctor and a patient. But having said that, India is a especially in the government hospital, India is a place where so many patients are there, and a doctor has a very restricted time. How much, is there a time? First question is there any standard of care? Saurabh, hang on, just Dr. Mishra, just one second.
Saurabh, I have understood your question. I just want to quickly respond to you because we'll run out of time. I would have to go at 10:30. So I'm just quickly want to tell you there's nothing called public and private hospital. Hospital is hospital.
No, my question is different, Dr.
Between
Mishra.
X and Y. Healthcare cannot be compromised at any cost. So we are telling the government that all government hospitals should also get accredited or certified under certain standards.
Absolutely.
So we are demanding that, and we should keep demanding that. We cannot hide behind saying so many patients are coming. We have to say that even if X number of patients come, we must have the facilities and the infrastructure ready to handle them.
Yes, Dr. Mishra, my question is a little different.
That's all. Simple.
My question is a little different.
Saurabh,
just one second.
One intervention. Saurabh, one very important observation actually. See, Ira has said it, lack of communication is very important. Communication is not only by way of words, by talking to the patient. Communication can be like a stato which our beloved KK Agarwal used to put on his neck every time.
Absolutely. Yeah.
When that stethoscope he may or may not have used on that particular patient.
But that was a confidence.
That gave a confidence that he's a doctor. He's going to treat. One of a very popular director, my senior, when I asked him why you're so popular, he gave me only 2 clues. That as soon as you touch a patient, try to touch a patient as soon as possible because you've got lack of time. So what actually a Nadi wale Vaid, why they were popular, Nadi wale Vaid, kyun popular hain? वो हाथ पे नाड़ी पे हाथ लगाते हैं, and that gives communication to the patient. ठीक है,
Absolutely.
People are using stethoscope on the chest, whether patient requires or not. If you just put a stethoscope on the chest, put your fingers on his pulse and try to communicate, you have developed the confidence at that particular stage only.
I would personally have an experience on it. I was on a flight and I saw somebody not well, and he was losing his, because he thought that he will not be there. The moment he realized there was a doctor on board and he was there to check, he was all right. So that was a confidence which comes when a doctor is standing next to you or a medical professional is standing next to you. Coming back again, the communication part, which I was trying to ask, it doesn't matter whether it is a hospital, which is a government or a private. Since we have a lot of patients around, and the communication which Dr. Vats said that, it is important how you communicate, it cannot be just a verbal, but is there anything defined that how much time does a doctor needs to give to a patient, or how, like what kind of information needs to be disclosed and whom needs to be disclosed? Because there is always a sensitive aspect that you cannot disclose a lot of things also.
So whenever a patient comes, it is a protocol, and in fact, all the doctors are even taught in their MBBS also about this, and it is mentioned in the ethics also, that they have to sit down and talk to a patient, know about his history, tell him about, in fact, and first and foremost, every doctor has to tell him about himself to the patient. What is his expertise? What is his experience? What is his qualification? How many patients he has actually treated, so that the patient gains confidence. And then the doctor has to know about the history.
But then what is a patient's duties? What are the patients, what they are doing, when they are going to a doctor, obviously they go with an experience, they go with a research. Like if doctors,
all patients are coming with experience,
yes,
all patients are coming with,
so there has to be rights and duties for a patient as well.
There are rights and duties of the patient. There are duties of the patient, of course. There are defined duties, but because we have it's a very big and topic, and we are short of time.
Absolutely, this is a very big topic. We cannot cover it in a one session.
About the duties of the patient and rights of the patient, it's just a 1 hour discussion. It's a huge topic.
Okay. So one more question coming up, which we would like to take it before we can end the session. When we talk about a medical negligence, and then we can take the questions on the floor as well. When we talk about a medical negligence, this question is coming up. How do you differentiate between a medical negligence from a doctor's point of view and a service point of view, which could be the hospital, which could be the ambulance, which could be the the availability of a medicine, availability of a resource? Doctor may be doing his own duty at his best, but there could be a medical negligence. How can you differentiate who can be more, a party to it?
For line of treatment, all your medical reports and medical documents are there, which talks about the treatment given by the doctor. So if your documents, medical records are in line, they are properly signed, they are properly filled, then yes, the doctor, and other medical errors, deficiency in service, which can be like, suppose the patient was not given room on time, patient was not given proper food, or patient was not given, there was a problem in medical device. So that is a different scenario and situation which can be easily come out if your documents are there in line, and your medical documentation is very important part.
Documentation is very important. Okay. Dr. Arora, would you like to ask a question? Yes, Dr. Vats.
Very important point in it. See, it is the patient goes to Paras Hospital, Medanta, or some hospital to get a treatment from a doctor, and he surrenders himself to the doctor, and doctor has to be in complete control of the situation. It is expected. So you cannot separate the negligence being done by the paramedical staff or by the hospital management. That's why in the initial stages I told that if a doctor sees that these lacunas are in that particular hospital, he should leave or quit that particular hospital. He cannot touch upon that it is because of the management. He has to ensure, because patient, he is the treating doctor, and every responsibility goes off him on. So he has to ensure, he has to talk to the management that those parameters which he thinks is appropriate, he should either get it implemented in the particular hospital, or he should leave it,
Okay.
which
Okay.
we are not doing. Moreover, suppose there is a death on the operation table, all that. So in that particular case, it is become difficult for the patient and for the judiciary also. Who is at fault? So that's why in that particular cases, all of them are taken to the task.
Okay, so ignorance is not the party to the law. And second, the communication documentation is important. These are the takeaway messages. Yes, Dr. Arora.
Sir, I have a question. What is the status of the offline or off-label drugs? Use of
Off-label drugs.
We have been using this very frequently, even during Corona times, as we have seen ivermectin, hydroxychloroquine. We have been using these things on just observations or our experience. And I'll give you a particular example of my case in thalassemia. What we use, there is a drug called thalidomide, which increases the hemoglobin value. There are many short studies, observations, small studies are there, but it is not a standard of care. So if we use such type of drugs in our practice, how it is going to affect the medical legally?
See, what exactly happens, it is expected that a doctor has to take risk. He has to take risk of judgment because patient doesn't know ABCD about those particular things and all that. Doctor having knowledge or expertise, he can think that this is possible. If I do this line of action, patient can be treated. Yes, there can be some harm or there can be some complications, but he has to weigh whether I should take that particular risk and should give at that particular medicine. And that in this circumstances, again, what Ira has told and other doctors are also tell, communication is very important. That while you are giving some person HCQ, you must speak one line to him also that why I'm giving it. You can have problem, why? But still, I don't have any alternative. I have to take risk. You have also to take the risk. And law says, yes, that risk, doctor, he has to accept it.
Just to add in this about off-label drugs, there is no law on off-label drugs in India. And since last 3 years, Dr. K.K. Agrawal had been working on this issue, and we have even filed PILs and a lot of representation before the government and the courts also, that they should, now it's a high time that the government should come out with the law on off-label use of drugs. So hopefully we will have something on this topic also in near future.
Absolutely, and that is itself is a big topic. We have done a lot of work on it. Also, I think I would like to also make a point over here that, Dr. Vats just talked about risk. I also see that because there is so much of medical negligence cases are coming up and a lot of doctors are being put on the scanner. There are times when doctors are also becoming a risk adverse. They are taking a lot of precautions before they treat a treatment to the people, and which is also increasing the cost to the patient, because what doctor used to do it on their experience before that, okay, this is a case of perfect this and let's start the medication. Now on a safer side, because of this documentation part, they're adding more treatments just to make sure that, the treatment they're prescribing may be in line with whatever the laws and standards are there, and which may increase the cost. And with this, if anybody wants to put a point on it, and then we will take question from Mr. Wadhwa.
Saurabh,
Yeah.
you are very much right. Before Consumer Protection Act, and from Google knowledge, the threshold of risk-taking threshold of the doctors was very high. But now, because of the CPA and because of this particular, the threshold of the doctors taking risk has come down, and it has increased the cost of treatment many-fold.
Absolutely.
And that is also the cause of cases being thrown of the medical negligence.
So, pehle ke zamane mein doctors used to give medicine which was not labeled, like which was in the things, and people used to get fined because there was a confidence. There was a confidence from a doctor to a patient and a patient to a doctor, which now probably in this world is very different. So that is my reason. Yeah, Mr. Wadhwa, tell me.
I work in a government medical college in Haryana. And Dr. Pankaj mentioned that if there is, deficiency of service, everyone is liable for action. And you also mentioned that if I find that there is a deficiency of service in my setup, I should just leave and go ahead. Is it possible for the government doctors? And what happens when I find myself at my wit's end at the end of OPD and there are about 40 patients waiting? I am absolutely tired. My medical liability remains the same. But I'm not in.
But Dr. Wadhwa, luckily you were saved and we were saved because Consumer Protection Act has not included government doctors in that. However, certain cases has come up where the things has gone in, but you are very right. The government doctors are not come under the ambit of the CPA because they are not taking money from the patient. They are serving on behalf of the government. So that's why though they are morally responsible for that, but because they are not covered in that particular thing, so they have some relaxation in that matter.
It's some relaxation. It is not complete relaxation.
Just one.
I mean, even if a case is fired,
not complete relaxation. You can be. There are certain cases where medical negligence cases or section 604 have been leveled against the government doctor also. That comes in other. See, then your criminal negligence cannot be taken over.
Sir, just
only you are protected from the compensation or the CPA.
Okay.
Yeah, but criminal negligence you have to face.
Who is responsible for the action of postgraduates or those who are being trained?
Yes, you're right. What exactly happens in a very big hospital, which these are giving, say, DNB degrees and all that. So, under PNDT Act, only a doctor registered under the Act with the government can only. But I have to make aware and tell those big hospitals, DNB and all that you have to get them also registered. Otherwise, they cannot touch this machine. So, but we don't know. So that's why. And moreover, what exactly happens, then now several medical laws, non-medical laws. See, like latest acquisition of 6 big hospitals in Gurgaon. How it happened? What act was there? Do you know what act was there? This is the Acquisition and Requisition Act of 100 years ago, which gives the power to the district magistrate to acquire. They can acquire even your own house, your house also. In Gurgaon, the hospitals, their staff, their building, everything was acquired and handed over by a 689 order. Nobody knows about it. So that's why now doctors has to have in some medical legal clubs should form, and where every day they get updates about this also.
Sir, just to add one thing, what about a charitable organization where the doctors are not charging any money? If it is
they are not covered under this protection which the government hospitals are. Even if you do some charity and negligence, then you will be sued.
I think financial aspect is not a key to negligence for anything. So I think commercially it's different, and but medical is medical. You know, when you go to a doctor, he's not charging; it is his wish. But I think the negligence and everything will cover it. Am I right?
Yes, you're right. Absolutely.
Even in government hospitals, like Dr. Vats rightly said, they are only covered safeguard from the CPA, Consumer Protection Act, which only talks basically is of maximum the remedy with the patient gets is the compensation amount. But if the doctor is grossly negligent and indeficient in providing his service, then disciplinary action can be taken against the doctor under MCI or relevant authority under which he has been registered. Criminal proceedings can be initiated against him. So, and there is one concept called contributory negligence. So when we are talking about the management's fault or the paramedical's fault or the doctor's fault or not, we also see the contributory negligence, whether the patient has suffered injury not only because of the line of treatment given by the patient doctor, or because of the other factors which has contributed to his injury. So like it can be anything, hospital acquired infection or any other reason can it be. So there is a concept called contributory negligence which also has to be taken into account when we are seeing whether negligence is gross negligence or not.
Okay, so
Yeah,
we will.
Ira, you're right. This contributory negligence topic comes for the patient also. He can also be held for the contributory negligence.
Okay, so
he can also contribute.
They don't follow the follow-up. They don't take medicines on time. They are very negligent in taking any precautions what they are required. So all that is a contributory negligence. So when we see what the line of treatment is, when in every particular case we have to see each and everything. See, medical itself is a very abstract thing. There is no yes or no, and law is also very abstract thing. There is no yes or no. So all the factors have to be taken into account. Every case is a different case, and every case has to be seen and analyzed properly. And like Dr. Professor Mishra said about neutral body, that is important nowadays. Doctors and hospitals should refer their cases to the neutral body. If at a majorly 99% cases, the patient complains about any kind of injury or medical negligence to the hospital directly, first to the hospital and the doctors before going to the court. If at the first instance we are able to remedy and find out the reason and have him settle and understand the problem what he has faced and he also understands our line of treatment and our precautions being taken, then I don't think any medical negligence case will go up to the court.
So what Ira mentioned,
Ira, what exactly is the problem? The problem is with the attitude of the doctors. Every doctor thinks that wo park saaf hai and he is doing his job very perfectly. All the hospitals also thinks that their system is very, very appropriate and they are working very best. They have hired very management skilled people and all that. But internal audit of services, that is very important, which we lack. See, NAB accreditation, another thing that Professor Misra pointed out, we get a NABH hospital accreditation. Now it gives you, several times it has happened that there were so many lacunas, but still that certificate was given. But NABH hospital gives more liabilities on you, that you are NABH hospital and still you did this. So that's why even in spite of the NABH hospital accreditation or other accreditations, you must have an external audit by experts.
Okay. So in the interest of time, I don't think we can make justice to this topic, which includes multiple subtopics. And but I have a lot of questions coming up, which we can take later. But I will ask 3 questions more, and the answer should only be in yes and no. I know it cannot be justified, but can a hospital or a doctor refuse? Can a hospital or a doctor refuse if he's overburdened with the patient to take patients? Is that a negligence? Yes or no?
The doctors and hospitals are supposed to stabilize the patient. If a patient is coming to them in emergency and he's not in a stable condition, then the hospital or the doctor cannot say no to any patient. They have to stabilize, and it is there in the code of ethics also. In their code of ethics, they have to follow it.
Saurabh,
What they can do is they can say that we don't have to, because every hospital and every doctor is not competent to treat all kind of patients. So they can at least help him out to refer it to some other hospital or the doctor.
Okay. In the
Saurabh,
yes,
can
sir.
you give me permission that I can take my breakfast simultaneously? Because
So we are just closing the session within a minute.
In a hotel, वहाँ पे सब बंद कर देंगे तो मैं साथ-साथ खाते-खाते क्वेश्चन
Yeah, definitely. We are closing the session anyways in a minute.
No, you can do it.
The last question which I want to ask is, certain treatments, especially this pandemic, there was no guidelines. Ivermectin became a very big news. Is there any law which says where the protocol was not predefined or something which is there? Can the doctor be held responsible for the negligence or something? Is there any legal time binding? Dr. Nidhi rightly said guidelines are to guide. Are they also the legal terms, or is that just a guidelines which doctors have to follow? And if in case there is no predefined treatment from, let's say, authorized government or government side or from WHO side or from where, can a doctor be held responsible even if his whole intention was to save the patient?
Yes, Saurabh, I rightly pointed out on 4th and 5th September, which took place, KK Agarwal's program था, sir का, मैंने वहाँ पे भी point out किया था कि there is no protection. That's why I told that a protection which are given to the officers and officials under those acts must be extended to the treating doctors and clinical establishments also during the period of epidemic and during disaster management. Otherwise, you will see it, then notice were served to several hospitals only on the point that they were giving injections in the basement and immunization which we are doing it. And they said it, there is no separate portion there for their taking rest or keeping for 30 minutes and 40 minutes at that particular site. However, they could have come on the reception and they can sit there. So they were given notices and actions were taken against that. So there is no protection till what I suggested was that they have to be included under that clause which give protections to officers or government, state and center, that no action can be taken against, no suits can be filed against them.
Okay. Thank you. I think we will end this session with an announcement that what Ira mentioned, that any dispute arising should be amicably settled with a neutral party. Heartcare Foundation of India does have a mediation cell which they are running over the period of time. Dr. KK had this concept where we do get involved in as a neutral party to help the patient and the doctors and the medical professions. No dispute is arising because somebody actually went into a hospital to get into a dispute. It was neither a patient's intention nor a doctor's intention. Their both intention was to serve the society and the patient was to get a treatment. A communication is very important. Documentation is very important. So yes, we do have that platform as well available. With this note, I would like to thank Dr. Pankaj Vats, who actually came and throw the light on this topic, and from the doctor's point of view, from the medical point of view, and Advocate Ira Gupta as an advocate over here, and all other dignitaries who were there present for this topic. With this note, I would like to end this topic. We will take further more sessions on this topic. It was very, very short, brief introduction. We will do further interaction on this topic. Thank you everyone for joining in. See you again next week.
Thank you.